When you receive a summons from a Polish civil court to testify at a hearing, the summons will identify the parties to the dispute, what is at stake in the dispute, and the court before which the case is pending. At the end of the summons, you will find a notice on the penalties you face for failing to comply with the summons.
Now you're probably wondering, do you definitely have to participate in the hearing? What rights do you have as a witness? What are the witness's obligations? How will the testimony be taken?
My name is KONRAD GROTOWSKI and this is News from Poland Business and Law, a program prepared by lawyers from Wardyński Partners for foreigners acting as board members in Polish companies, foreign investors in Poland and their foreign advisors. My guest today is STANISław DROZD, attorney, solicitor-advocate of England and Wales, not practicing, and a partner at Wardyński Partners. Together we will answer above questions. Let's first explain who a witness is.
A witness is a person unrelated to the parties. The dispute does not concern the witness's rights or obligations. In this respect, if a company is a party to a dispute and the court hears the testimony of the company's management board members, they will testify not as witnesses, but as a party, as the board members in some sense embody the company.
Who indicates to the court who should be called as a witness in the trial? Witnesses are identified by the parties, by the claimant in the statement of claim and by the defendant in the statement of defense. Is it possible to refuse to testify? As a rule, no. A person called as a witness in a case between two companies, the most common situation in commercial disputes, has no right to refuse to testify. A witness, unlike a party, has an obligation to testify.
There is an exception when one of the parties is an individual and the person called to testify as a witness is the spouse, parent or child of the party. Such a person has a right to refuse to testify, and before the hearing the court must instruct the witness of this right. In addition, during the course of the hearing, any witness, even one unrelated to either of the parties, can refuse to answer specific questions if the answer could expose the witness to criminal liability or a serious and immediate financial loss, or if the testimony would violate professional confidentiality.
What can you do if you cannot appear at the time stated by the court?
An anticipated failure to appear, for example due to illness or a previously planned foreign holiday, should be justified. However, a failure to appear due to illness must be justified by presenting a doctor's certificate, and not just any doctor. The certificate must be issued by a special court-appointed doctor. This is intended to protect the judicial system against the abuse of certificates issued by friendly doctors, which used to be a common problem in Polish court hearings.
What happens if a witness fails to appear with no justification? The court can first impose a fine on the witness. The current amount is 3,000 Polish zlotys, about 650 euro. Then the court will once again summon the witness to appear. If the witness again fails to appear, the court can again impose a fine on the witness. But it can also order the police to bring in the witness by force from their home or workplace. What form does the testimony take? The rule is that the witness testifies orally.
But the court may order the witness to testify in writing. In that case, the court will issue a written summons to the witness, specifying the factual issues on which the witness will testify, presenting the questions to be answered by the witness, these are formulated by the lawyers for the parties, and setting the deadline by which the witness must send answer to the court by post. The court will also instruct the witness of the penalty for perjury.
Where is the oral testimony taken? Before the COVID-19 pandemic, the rule was that witnesses testified orally during a hearing in the courtroom. But at the start of the pandemic, testifying during remote hearings became the rule.
The court can decide to hold a hearing in person rather than remotely when conducting such a hearing is necessary for the case, and conducting the hearing in the courthouse will not pose an excessive risk to the health of the participants.
Currently, a party calling a witness provides the witness's mobile phone number and email address to the court. The witness receives an email from the court with a link to the online connection. On the day of the hearing, at the request of the court made by telephone, the connection is switched on or off via internet.
This concludes the first part of the program on interrogation of a foreigner as a witness before the Polish Civil Court.
We will soon publish the second part of the program on this topic. See you then!